You need to have little patience because this is going to be a little lengthy session. Why? Because Accomplice is not just section 133 of Evidence Act but is a beautiful legal concept. We are going to understand the meaning of Accomplice. We are going to understand section 133 of Evidence Act. We are going to understand the relationship and consequences between section 133 and section 114 illustration B. We are also learning why not to consider straight away the witness given by Accomplice. We are learning the different categories of Accomplice. We are also going to understand the difference between Accomplice and co-accused. We are also going to understand section 306 of CrPC 1973 to understand approver getting pardoned there and the concept of approver and case laws. Yes, to understand all of these, we need to invest some time. And remember, all these concepts are interconnected and questions can be framed anyway, and this one session almost gives answer to all of those questions. Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Evidence Act, we were discussing chapter 9, that is witness, covered between section 118 to 134. We now are discussing section 133, which is one of the most important section from Evidence Act, which is all about accomplice. With that brief introduction, I am taking to my first slide, which is all about the meaning of term accomplice. I have dedicated my first slide to understand the term meaning of accomplices. Now I have given in different language what an accomplice means. In Hindi it is Satyo, in Kannada it is Sahachararu, in Telugu it is Sahacharalu. Likewise I have given in Tamil and Malayalam also. Who is an accomplice? Accomplice is a person who helps another to commit a crime. Yes, most of the time accomplice comes with criminal cases, though there are possibilities for accomplice in civil cases also. Most of the time it is a criminal term where one associated with another, especially in committing some crimes. A person who helps someone else to commit a crime or to do something morally wrong is known as accomplice, and English common law has defined it as an accomplice is a person who actively participates in the commission of a crime even if they take no part in the actual criminal offense. Likewise, Black Law Dictionary says a person who knowingly, voluntarily, and with common intent with the principal offender unites in the commission of a crime is considered as accomplice, or one who is in some way concerned or associated in commission of a crime is accomplice. Here you might be getting a question that if a person has done aiding or abetting or advising or encouraged someone to commit a crime, but when the real crime happened, such person was not there in the crime scene. He has just aided or abetted or advised or encouraged but not present in the crime scene. Can we consider such person as accomplice? And the answer is yes. Mere absence will not make him innocent, and that is one very important aspect we need to remember. But on the other hand, imagine you are walking on a road and someone comes and kills another person in front of you. Now you have witnessed it. You have never tried to stop it. You have never told to anyone about this, or you have made a false statement that you were not there in the crime scene. Can it make you an accomplice in that case? And the answer here is no. Just having knowledge or just concealing the fact that you have the knowledge, or just by falsely denying that you had the knowledge, or just because you were silent, or just because you never tried to stop the crime, that will not make you accomplice. That is a very important aspect you need to remember. And for all of these aspects I have told, I have case laws in this slide. Take a screenshot and quickly go through. With that, I am taking you to all important section 133 and there is another section coming in with the form of an illustration, that is section 114. Both of them are in my next slide and I will discuss them in detail because you need to have the knowledge of section 114 illustration B while discussing section 133 because they are connected. If you don't know one of these sections, then you will get confused, and if you read them separately also you will get confused. So these two confusing aspects I have brought in one single slide, and I will ensure that we will end up with no confusion. But before everything, let's quickly read out the legal provision as to section 133, and it says an accomplice shall be a competent witness against an accused person, and a conviction is not illegal merely because it proceeds upon the uncorroborated testimony of an accomplice. Now, by the discussion from my previous slide, we know the meaning of accomplice, so I am not getting in there. That is why I am straight away getting into the chart on section 133, which says an accomplice shall be a competent witness. That is the first and foremost important aspect you need to remember, that an accomplice shall be a competent witness. And with that line we will have clash with section 114 illustration B, which I will discuss further. But let's now focus on my chart, which continues against an accused person. Now an accomplice becomes a competent witness against an accused person, and conviction of such accused is not illegal just because there is no corroboration. Now, if there are no corroboration to the witness given by the accomplice, the conviction will not become illegal. That is a very important aspect we need to remember. An accomplice shall be a competent witness against an accused person, and conviction of such accused is not illegal just because there is no corroboration to the witness by an accomplice. That is what you need to understand from section 133. Here, there is an accomplice who is giving witness against an accused, but though there is corroboration missing, the conviction will not become illegal when such witness is given by an accomplice. With that, let's discuss on section 114 illustration B and then try understand how to read them together. What does section 114 discusses about? It discusses about court may presume existence of certain facts. It gives the right to the court to presume that certain facts are or were existed. Now this we have an independent video. However, for now let us focus on illustration B, which discusses about the court may presume that an accomplice is unworthy of credit unless he is corroborated in material particulars. Now there comes the clash. Section 133 says an accomplice is a competent witness, and without corroboration also his testimony is a valid testimony, and with that conviction is possible and the conviction will not be considered as illegal. Whereas under section 114B it says an accomplice is unworthy of credit, and unless he is corroborated in material particulars his witness is not competent. Now how to read them together? To understand that, we need to understand case laws, and I have two dedicated case laws to understand section 133 and 114B together, which we will discuss at the end of the presentation. But for now, there are two important illustrations given under illustration B, in which the first one comes with a witness given by an accomplice who is having highest good character. In that case, the witness given by such accomplice who is having good character was considered as valid witness, whereas in another illustration there were three people caught in the crime spot, that is one Mr. A, B and C, and they were all kept in separate places, and when they asked question about who has committed the crime, all of them told D has committed, but they have given different facts. In that case, the material corroboration on their statement is very, very important. Now, an accomplice cannot be just trusted like that. 133 though says that he is a valid witness, he cannot be trusted straight away. And why not? The same has captured in my next slide. The answer for the question why not to consider an accomplice witness as a competent witness is quite simple. A person who is party to crime, he must be having a bad character, and only because of his bad character he became the party to crime. And to what extent we can believe the statement given by the person who is having bad character, or the witness given by the person who is having bad character? And what is he doing? He is giving witness against his own partners with whom he has committed crime. If he can backstab his own partners in crime, he can definitely do whatever he wants. Now, we cannot trust such person, and by doing so, what is the benefit for him? He is getting benefit under section 306 of CrPC, which I am going to discuss in my future slides. And by using that section, he becomes free from punishment, and that gives him more and more opportunities to repeat the crimes. And it can also risk others unnecessarily, and by taking his witness without due corroboration may result at injustice. And to ensure that justice is prevailed, we need to take sufficient care. Now, as I already said, an accomplice is a person who is usually having bad character because he is partner in crime. And such person, whether he understands the sanctity of oath or not, and the answer may be he is not respecting the sanctity of his oath. And such person giving witness and accepting his witness without corroboration might risk others, or he may be just trying to save himself, or he may be giving a false approval. He being selfish person, we cannot rely him on straight away, and there are chances of implantation of such accomplices by the people who have benefit from such crime. Now, considering all these reasons, we should not accept the witness given by an accomplice so easily. One another very important question when it comes to accomplice, or the concept that you should know, is categories of accomplice. Remember, you might get an independent question on categories of accomplice for short notes. When it comes to that question, all you need to do is elaborate this particular slide. There are 4 important categories when it comes to accomplice, and the first 2 are the principles of first degree accomplice and the principle of second degree accomplice. What does it mean when it says principle of first degree accomplice? It's very easy. When there are multiple people involved in a particular crime and their roles and functions are same in a particular crime, and when there are full participation by each of them, that is considered as principle of first degree accomplice. Like for example, when a robbery happens, all the robbers have same type of roles and functions, and they are all functioning at the same time at the same spot. When they all have similar role to play and they all are functioning at the same time in a same place, that will be considered as principle of first degree accomplice. The principle of second degree accomplice is little different. Here what happens? Few are playing the major role in the crime spot, whereas others have supporting or assisting role. Like for example, A, B and C want to murder Mr. X. Now here A and B are waiting for Mr. X to come to a particular spot to murder him. And the role of Mr. C is to ensure that Mr. X is reaching that spot. Now he is supporting or assisting A and B by ensuring that X has reached the spot. Now here the role of Mr. C is coming under principle of second degree accomplice because he is not participating in the actual crime spot, but he is ensuring by his support or assist that the crime has happened. Now that is principle of second degree accomplice. The next two are accessories. One is being accessory before the fact and the next one is being accessories after fact. Now what is being accessory before fact? Here someone is becoming the part of the crime or becomes an accomplice by the part of preparation of crime. Like for example, provoking someone, counseling someone, convincing someone, encouraging someone, procurement of weapon, all of these are accessories before fact because all of these are done before the actual crime has happened. The preparation is being accessories before fact, but being accessories after fact is supporting after the crime is completed. Now when the crime is completed, if the accomplice was there in the spot, then that comes under principle of first degree accomplice. But he was not there in the crime spot, neither the part of the crime, but he supports after the completion of crime. In that case, that is considered as being accessories after fact, and the examples are like helping them to hide after a particular crime is committed by few people, or helping them to escape, or helping them to hide the weapon which is used for the crime, or burning the dead body of the person whom they have murdered, etc. Here the person is not participating till the crime has happened, but once the crime is completed, he helps those people who has committed the crime. That is known as being accessories after fact. So these are the four important categories you need to remember. That is principle of first degree accomplice, principle of second degree accomplice, being accessories before fact, and being accessories after fact. Before concluding categories of accomplice and getting to the difference between accomplice and co-accused, I would like to quickly throw some light on the essentials to consider someone as an accomplice. You cannot say anyone and everyone as an accomplice. There are few essentials. Like for example, to consider a person as an accomplice, he or she should have the knowledge of crime. They should be aware that a particular crime is going to happen and he or she has supported in preparation or during the crime or after the completion of crime. If they were aware and supported, only in that case they will be considered as an accomplice, either supported or acted upon. The second very important essential is, if somebody is doing something without consent, that means free consent, that will not be considered as an accomplice. Like for example, some of your family members are under threat and the people who have kidnapped them say, if you are not giving any information about X, they might cause harm to your family members. Now you are giving information about Mr. X, though you don't want to, but you are giving to protect your family members. Now here you have given information under threat and that will not be considered as accomplice. That is second very important essential you need to remember. Thirdly, just because you have seen something or just because you have not tried to stop a crime, you will not be considered as accomplice. While explaining the meaning, I have already told, seeing, witnessing, not trying to stop or giving false statement or hiding the information, all of that are not coming under accomplice. Only when you are party to a particular crime by being the accessory before fact or first degree or second degree participation or being accessories after the fact, you become an accomplice. Otherwise, you will not. With that, I am taking you to the next slide where we will understand the difference between accomplice and co-accused. When you hear the term accomplice and co-accused, most of the time we think that they are the same concept called in two different names. I will not dispute that it is wrong. It is almost right, but when it comes to Indian Evidence Act, we need to be little sensitive because they have different aspects covered about them. Now, when it comes to the sections, the concept accomplice is discussed under section 133 and section 114 illustration B, whereas co-accused is discussed under section 30 where we are discussing about the confessions. Here under section 133 we are discussing about the witness by an accomplice. Now that is about the sections. The second difference is which has the evidential value. Remember section 133 which is discussed under chapter 9 of Evidence Act, which is all about witness by the different people. Now here the witness given by an accomplice has evidential value, whereas under section 30 we are discussing about the confession by co-accused and it doesn't have evidential value. And why so? To understand that, we need to understand the third difference. Because section 133, witness is given on oath by an accomplice. But under section 30, confession by the co-accused is given without oath. When you are taking something on oath in court, it has evidential value. If you are taking confession without oath, that doesn't have that much of evidential value. The fourth difference is about the place where the witness is given. Section 133, the witness is given by an accomplice only in the court, whereas under section 30, the confession given by the co-accused can be anywhere and to anyone except police. That is the fourth important difference you need to remember. The fifth difference is about cross-examination. When an accomplice gives witness or evidence under section 133, the same can be cross-examined, whereas under section 30, when a co-accused confesses, that can't be cross-examined. That is the fifth important difference. Under sixth difference, I am discussing about conviction. Whether conviction is possible on the basis of the evidence given by accomplice under section 133, and the answer is yes. His witness is sufficient to convict, but we need to ensure that due care is taken. That is what discussed under section 114 illustration B. Whereas confession given under section 30 by the co-accused is not sufficient to convict someone. The seventh difference is about corroboration. Under section 133, when an accomplice gives the witness, corroboration is not required. Though I am saying not required, there needs to be due care taken care, which is what we are going to discuss when we are discussing the case laws. But under 30, it is very clear when you are considering confession, there needs to be corroboration. That is very, very important aspect. These are the 7 very important difference between accomplice and co-accused. Also remember, accomplice is also considered as a prover under section 306 of CrPC 1973, and I have that particular section in detail in my next slide. We discussed about accomplice, we discussed about co-accused, and who is an approver. That is what exactly discussed under section 306 of CrPC 1973. I am not getting into the details of section 306 because it is quite lengthy section. But remember, section 306 discusses about tender of pardon to accomplice. Here, court may tender a pardon to such person on condition of his making a full and true disclosure of the whole of the circumstances within his knowledge relative to the offense and to every other person concerned, whether as a principal or abettor in the commission thereof. Here, if an accomplice gives an evidence, he becomes an approver, and for approver, court may tender a pardon. That is what discussed under section 306. You can pause the video or take the screenshot and read through this section, which is very important. And with that, I am taking you to case laws. The first two case laws I am discussing as to who is an accomplice. If you remember, in my first slide, I have given lot of case laws to define who is an accomplice. But here there are two important Indian case laws where you see the definition as to who is an accomplice, and it was in R.K. Dalmia versus Delhi administration case. Supreme Court held that an accomplice is a person who participates in the commission of the actual crime charged against an accused. Whereas in Chandan versus Emperor, it was held that accomplice is the one who is associated with an offender or offenders in the commission of a crime, or one who knowingly or voluntarily helps and cooperates with others in the commission of the crime. Here you see the knowing fact or being voluntary. All of these are very important essentials which we have already discussed, and I hope this gives sufficient notes as far as who is an accomplice, because we have already discussed in detail in my first slide. And with that, I am moving to other case laws. The next two case laws are very important, which are discussing about competency or reliability of accomplice witness. By understanding these two case laws, you can bridge the gap or the confusion between section 133 and section 114 illustration B. The first case law, that is Kashmira Singh versus State of Madhya Pradesh, the Supreme Court held that so far as the law is concerned, a conviction can be based on the uncorroborated testimony of an accomplice, provided the judge has the rule of caution, which experience dictates, in mind and gives reasons why he thinks it would be safe in a given case to disregard it. Now here an accomplice gives a witness, but the court, before accepting as under section 133, has to put rule of caution. Where does rule of caution comes from? It comes from section 114 illustration B, where he is not worth of credit. So both sections need to be taken care. Yes, there can be conviction without uncorroboration by the testimony given by an accomplice, but saying so, the judge should put rule of caution. And before coming to conclusion, he need to ensure that why he is coming to such judgment. That is what discussed here. The next case law, that is Rameshwar versus State of Rajasthan, it was again held by Supreme Court that if after the proper caution by the judge, the jury nevertheless convict the prisoner, the court will not quash the conviction merely upon the ground that the accomplice's testimony was uncorroborated. So it gives a lot of importance to section 133, but saying so, it starts with if after the proper caution by the judge. Now that is very important. That way section 133 as well as section 114 illustration B are taken care. Now let's move to little more specific discussion. There the competency or reliability of accomplice witness discussed in Kashmira Singh versus State of Madhya Pradesh and Rameshwar versus the State of Rajasthan. It was not specific to section 133 and 114 illustration B. But I have next two case laws which are specifically on section 133 versus section 114 illustration B. Now the question is, which one is very important? The same were discussed in the case law Queen Empress versus Chagan, and it was held by the Bombay High Court that neither section 133 nor section 114 illustration B can be ignored while taking accomplice witness. So who is important? It is neither 133 nor 114 illustration B. They need to be considered together, None of them can be ignored. Both of them are very, very important. Now, if the next question is among them which is very, very important, then we have to get into the case law, that is Emperor versus Srinivasa Krishna. See, the beauty of section 133 is it says court shall, whereas under section 114 it is may. So the question between 133 and 114, it is always section 133 plays a bigger role because their court doesn't have any opportunity. It says it shall. So that way it becomes absolute. However, in this case law it was held that while section 133 is the absolute rule as to accomplice as a witness, the judge should also give regards to the illustration B of section 114. Yes, section 133 is shall, section 114 illustration B is may, but even then the judge should give regard to illustration B of section 114. That is what held here. So that way, while deciding a particular case, if an accomplice is a witness, court should give regard to both section 133 as well as section 114 illustration B, and with due caution the judgment should be given when an accomplice witness is taken. That is what we need to understand from the entire discussion. That's my time on the term accomplice. I will not say it has covered everything. None of the legal aspects can be covered over a session. You can further watch many more videos for more inputs on accomplice, and remember, this is one of the most important and beautiful aspects from the law. Before concluding, we have this habit of having New Year resolutions. But my question is, why to wait for New Year? Your new resolution, if it is good for you, you start any day, and that day is a good day to start. With that, I am concluding. Please subscribe my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are watching my channel, and thanks again.